All right, so let's talk about covenant enforcement. All right, so as usual, I'm starting with a little cartoon. As you can see, there's a tree that's been thrown through this owner's window. And the note says, maybe next time you'll think twice before planting a bush not approved by the neighborhood association. Again, this is the view people have of associations. We are overly aggressive. We're looking for any technical violation. And if you screw up, we're going to throw a tree through your window. All right, so I'm going to talk about what are restrictive covenants, how to interpret restrictive covenants, enforcement procedures, statutory due process requirements, non-judicial and judicial remedies, and then best practices. So enforcing restrictive covenants is primarily governed by the declaration. It's also governed by Chapter 81 and 82 of the Property Code if you're a condo association, and 209 if you're a subdivision association. So your home is your castle and you are the master of your domain. This is actually a real property that we worked on. Somebody built a castle in a residential neighborhood, and I think
it's not far from here.
No, it's not.
Yeah.
And it's really pretty cool. So unless your property is subject to restrictive covenants, then it's not quite your castle. The enforcement of restrictive covenants is one of the most challenging endeavors faced by an association. It's one of the places where, as a board of directors, you really are going to be asked to use your discretionary authority and take into account a lot of different factors. It is full of high emotions. It generates full-on what I call neighborhood disputes, where you really do have the folks sharpening the pitchforks and lighting up the torches. And it's just a good rule of thumb to understand that emotions run higher and tempers shorten the closer an issue gets to a person's front door. I think that's the best explanation I can give for why people get so out of control fighting about these issues. So here's the big picture. A declaration is a private contract that runs with the land. You've seen this slide a couple of times today, but it's important. You've got 3 obligations that you can find in a declaration. Mandatory membership in the HOA, you've got to pay your assessments to the HOA, and you must comply with the restrictive covenants. Now, the restrictive covenants are contractual obligations that are imposed on a lot or a unit, and they require a homeowner to do one of 2 things. They can require you to do something, like maintain your yard, or they can order you to refrain from doing something, like parking a trailer in the driveway. Who can enforce restrictive covenants? And this is important. It's not just your association. And I mention this so that you can have an out when people are complaining about a neighbor and you don't believe that it rises to the level of what the association should be involved in. So anybody who's a property owner can enforce the restrictive covenants, which means that just because the HOA doesn't want to get involved in one of these disputes about a particular violation, you can always let the owner know, hey, if it's worth it to you, go hire a lawyer and you can sue your neighbor and have them cut the grass or take in their trash can or whatever it is they're complaining about. Restrictive covenants are intended to preserve and protect property values and also protect a homeowner's peaceful enjoyment of their homes from being affected by certain acts or circumstances. Now, restrictive covenants are there to protect you from things like a junkyard, an unauthorized repair. I mean, that looks pretty nice. It just doesn't match very well. This is one of my favorites. This is from a lawsuit we had where somebody was complaining about the junk in the overgrown yard. And when we went to go take a picture of it, there's a goat standing on the back of this. Goats were not allowed in this subdivision. So this is pretty awesome.
It's an emotional support goat.
Yeah, well, that's not even funny. I just got done with a lawsuit about emotional support chickens that I've been talking to you about later. So this is a car up on blocks. This is a neat little pile of garbage. These are overgrown weeds that I would say are out of control. This is your proverbial 18-wheeler parked in the front yard. I like to use that as an example, and there's the picture of it right there. That is a beautiful above-ground pool. Looks to me like either an eviction or a very upset wife. This is an inoperative vehicle. I don't know if you can tell from the picture, but there is no engine. So it's easy to tell that that one is inoperable. I guess you could tow it behind some horses, but I don't think that's what they meant. This is the result of an eviction. This, I don't even know what the problem is. That's pretty awesome. This one deserves an award. I mean, congratulations. You even got the roof to be pink.
It's private, but,
Yeah, no, it is private. So
but you're grabbing it.
that's right. Pretty awesome. This one is complete with emojis. This one I thought was a good use of patterns. That's just fancy.
Good mark.
This I really like because if you look closely, you can see that the windows have been painted on. Those aren't actually real windows. I would argue maybe that improves the look. This one is definitely in Austin. This is the Van Gogh residence. This one I don't even know what the problem is. And this one's for sure over there on 45th. Yeah, that's a good shot. This is my favorite. This is the result of a homeowners association telling an owner that their AC equipment has to be screened, and the result was they said, "Fine, no problem." All right. So getting back to the serious nature of enforcing restrictive covenants, the enforcement of restrictive covenants involves four main issues. You've got the interpretation of the restrictive covenants, how to enforce them in the first place, complying with procedural due process requirements, non-judicial enforcement procedures, and then finally the last ditch solution, the judicial enforcement procedures. So in general, courts interpret restrictive covenants just like any other contract, with one very important exception. First of all, these are the general rules of contract construction. So in general, if you've got a declaration, the specific language will control over general language. Each provision should be given meaning, which just means that you don't ignore one provision for another. Documents should be read as a whole. Captions and headings are not substantive. The most recent provision has priority over prior provisions in time. And you apply the plain meaning of words unless those terms are defined within the document or there's a very specific technical meaning. And then the best place to figure out the plain meaning of a word is you just look it up in the dictionary. We actually do that all the time. There is one exception to these rules. Texas is what we call a property rights state. You don't mess with the Texans' land. The Supreme Court disfavors restrictions on property, but believes in enforcing contracts. That's the balancing act that the courts are always trying to balance, and we still don't have a definitive result from the Supreme Court on an issue that I'll point out in a second. Now, to harmonize these 2 points, disfavoring restrictive covenants, but enforcing contracts, the Supreme Court adopted the strict construction rule. And that was this: a restrictive covenant will be enforced as long as it's clear and unambiguous. So you just look at it. If the plain meaning is obvious, we're going to enforce it. It says the setback is 20 feet from the road. That's easy. We don't have to interpret that contract. We don't have to look at first in time or any of these other ideas. We just know it's easy to interpret, so you interpret it. It's considered ambiguous, though, if the language cannot be given a certain or definite meaning. If the covenant is ambiguous because it is subject to more than one reasonable interpretation, that doesn't mean that just because somebody can come up with a way to read it the wrong way, that it's ambiguous. It has to be a reasonable interpretation. Then the court will interpret the covenant in the least restrictive way, or the least restrictive interpretation of whatever those multiple reasonable interpretations are. This was the common law rule for strict construction, and it was the law in Texas since 1925 at least. Now, in 1987, which we still refer to as the new liberal interpretation rule, the Texas legislature enacted 202003, and it specifically states in plain English that restrictive covenants shall be liberally construed to give effect to its purposes and intent, and nobody has any idea what that means. The intermediate courts have struggled with this, have tried to figure out what the balancing act is, and I think that in general, we have advice that can help you when you're interpreting these provisions. So the Texas appellate courts have been in continuous disagreement, and the Supreme Court has refused to resolve the dispute. So until the Supreme Court chimes in, it's going to be unresolved, and it's going to be a judge-to-judge basis of how these things are going to be implemented. So what do? We use the strict construction standard because if you do, you'll always be on the winning side of any disagreement that ends up in court. So that means look at the restrictive covenant. If there is a reasonable interpretation of that restrictive covenant that is less restrictive than what you're doing, take the less restrictive interpretation. If you do that, you're going to be in good shape. So no matter how well declarations are drafted, they may not always provide a cure for every ill suffered by homeowners. It's certainly fair to say that things like short-term rentals were not prevalent 10 years ago, maybe even 5 years ago. And so it is impossible to have a declaration that covers everything that you might want to prohibit in a neighborhood. If an action by a homeowner or a property condition is not expressly required or prohibited, then the such act or property condition should be treated as a non-violation. If you are looking around for ways to put somebody in violation of your restrictive covenants, and you're having to come up with real creative ways to do that, you're probably doing it wrong. If a particular restrictive covenant can reasonably be read or interpreted in 2 or more possible ways, the HOA should assume the least restrictive of the possible meanings and take that position. And if that doesn't work for you, then you probably need to amend your restrictive covenants, and then you're going to have to meet all the thresholds required by law and your declarations. Now, when it comes to enforcement, not all restrictive covenants are created equal. We've got easy ones and we've got hard ones. The easy ones are the ones where you've got an objective standard. For instance, no boats or trailers in the driveway. The violation, these types of violations are easily established by photographs. And if I take this to court, I'm going to be able to win on summary judgment. These are always easy to prove. You know, you do a survey and it shows that the particular improvement falls within the setback. These are objective things that are easy to prove. Boats in driveways, I can prove it with a picture. Disabled vehicles, there's no engine or it's up on blocks, so you know it can't be driven. Trailers in a driveway, there's no dispute what those are. Businesses being run out of a home, it's very obvious that this person is running an auto body shop out of their home. Construction without ACC approval, you can take a picture of it and it's easy to prove. Now we've got the hard ones. These are the ones where you've got a subjective standard, and the subjective standard is the reason board members exist. It's to interpret the restrictive covenants when it comes to things like unsightly materials, or your yard needs to be kept in a healthy and attractive manner, or no activities that can that are nuisances shall be operated on the property. These are things where you've got to use your judgment. These are also times when a summary judgment is not going to work because the trier of fact is going to have to interpret a subjective standard. So these are the ones that are more difficult. Examples are things like a zero-scaped yard. Is that being maintained in a healthy and attractive manner, or is that an overgrown mess? Again, it's going to be in the eye of the beholder in a lot of instances. Is a worn fence actually a nuisance, or is it something else? Sometimes the hard ones, though, become the easy ones. So is that a nuisance? Well, it turns out that's a little kid's boat sitting on top of a trailer. So maybe it is and maybe it's not. Modification of an improvement without ACC approval. Is that a modification? Is this a disabled vehicle? Now, I like this one because you zoom in and they've got a cardboard cutout there of 2 individuals. In reality, I think this was actually the Marlboro man. And so their position was every time the inspector drove by, they didn't give these people a violation for having a disabled vehicle because they thought there were people in the car and they just kept on driving. So it worked for quite some time. After 6 or 7 months, they realized that there was somebody, that nobody was in there and the Marlboro man was not about to drive away. So sometimes the easy ones become the hard ones. You've got a provision that says no boat, trailer, motorhome, etc. may be parked for storage in the front driveway or front yard of any lot. What does parked for storage mean? How long does it have to be there if it's being stored? If you move it once every 3 weeks, are you storing it or are you using it? Sometimes enforcement becomes impractical. So it says something like, for purposes of this declaration, vehicles or equipment shall be considered parked for storage if it is parked on or in front of a lot for more than 20 consecutive days without it being driven on a public street or thoroughfare. How on earth is a homeowners association supposed to ever determine if something has been parked in this manner? It's almost impossible. So it's important that you read your declaration, that you understand exactly what it prohibits and what it allows, and only try to enforce restrictive covenants that have any hope of being enforced. There are due process requirements that are codified in Chapter 209. This is for subdivision HOAs only. So before you can do anything with respect to enforcing a restrictive covenant in a subdivision HOA, you've got to send the homeowner a written notice that describes the violation, the damage, the fine, or the charges you're asking them to pay, states the amounts they owe the association, and includes a statement which informs the owner that they're entitled to a reasonable period to cure the violation unless it's uncurable or poses a threat to public health or safety, that they may request a hearing before the board of directors, and they've got 30 days to do that, and that they may have special rights if they're on active duty in the military. Now, the property code defines curable as a violation that is continuous and capable of being remedied. And then it gives examples that I think contradict the definition, but that's not really that important. So curable violations are things like a parking violation. You're in the wrong place. You can move your car and cure it. A maintenance violation. You need to repair your fence. The failure to construct improvements or modifications in accordance with plans and specifications. You gave them the authority to paint their fence brown. They painted it blue. They can fix that by doing what they said they would do. Or an ongoing noise violation, such as a barking dog. That one is one of the trickier ones. If it's a threat to public health or safety, that's a violation that could materially affect the physical health or safety of an ordinary resident. That doesn't mean that somebody with a particular condition can claim that a violation is a threat to public health or safety and get around the requirement of allowing somebody time to cure. If a hearing is requested by a homeowner within the amount of time that's required by statute, you must hold a hearing within 30 days of notice of their request for the hearing. You've got to notify them of the date, time, and place for the hearing within at least 10 days before the hearing. Again, this is for subdivisions only. And then if a postponement of the hearing is requested by the board of directors or the owner, it can be automatically extended for not more than 10 days. The homeowner or the HOA may make an audio recording of the hearing, and the homeowner does not have to be present. So if they say, I want to have a hearing, but I also don't want to be there, you have to conduct the hearing without them. In the 2021 legislative session, the Senate passed Bill 1588 and modified 209007 of the property code. It no longer allows hearings to be conducted by a committee. That wasn't being utilized by a lot of associations, but now the board is required to conduct the hearing. The board has to designate a director or other representative to present the association's case against the owner. That should just be a picture usually. And then the board is required to provide the owner a packet with all the evidence they intend to present 10 days prior to the hearing. And if they don't present that, then the hearing is automatically extended by 15 days. Now, if an attorney sends a violation letter to an owner prior to conducting the 209 hearing or before the period to request a hearing has expired, the homeowner isn't going to be liable for attorney's fees. This is important because a lot of times we're requested to appear at one of these hearings to represent the association. That's fine. We're happy to do it. You just have to understand that the violating owner is not responsible for our attorney's fees if the 30 days hasn't passed yet. So just keep that in mind. These hearings are really not that big of a deal. I know the word hearing kind of indicates that there's going to be some kind of legal proceeding, but it's just a meeting. The owner shows up and they say, hey, I got this letter. Here's a picture of my trash can. That's not my trash can. And then the board can go, oh yeah, I guess it's not. We waive the fine. It doesn't have to be complicated. And if it's a clear violation and they're just coming to yell at you, you can say, thank you very much. We'll respond to you in writing. And then you tell them that their appeal has been denied. So those are generally two of the ways that these hearings go. It's not necessary to have a lawyer there, but this does come up frequently, so it's important to point that out. Now, with respect to condominium associations, Chapter 82 also requires that you send a homeowner a written notice of the violation that describes the violation of the property damage, states the amount of the fine that you're going to ask them to pay, and includes a statement which says that they can also request a hearing within 30 days and that they are entitled to a reasonable period to cure the violation unless they were given such a reasonable period to cure within the last 12 months. You don't have to give them a reasonable period to cure if they're serial violators. And that's with respect to condo only. Now, you've got a number of rules of tools of enforcement for both condos and subdivision HOAs. You can send violation letters. I'm sure all of you already do this. And they're usually pretty helpful. Most homeowners want to be good neighbors. I know that there's exceptions to that rule, but most do. You send them that letter that says, hey, by the way, you left your trash can out. And most of the time, they're not going to do it again. So these are really good tools. You've got non-judicial enforcement methods, self-help remedies if they're authorized by your declaration. The most common one is a force mow. It's when you send somebody a notice over and over again, hey, mow your yard. They don't do it. The association sends the landscaper out, mows the yard, and then sends them a bill. The same provision that allows you to do that in your association can also allow you to go and fix broken fences, remove offensive items, tow cars off of people's yards, that kind of thing. It's just anytime you're doing something other than a force mow, though, you've got to be real careful because you're going to end up trespassing on somebody's property, and you need to do it in strict accordance with the declaration. You've also got the assessment of fines. That has to be authorized by your declaration. A general provision that says you can enforce rules and regulations does not authorize you to assess fines. If the word fine or damage assessment doesn't appear in your declaration, you shouldn't be fining people. If you're doing that, call us immediately. We can fix it. There's other ways to enforce deed restrictions, but you probably shouldn't be fining people.
Adam, how does this differ on the condo side?
In condominiums, you can assess people fines, even if it's not in your declaration. So this is specifically with respect to subdivision associations. It's got to be in your declaration. You can fine people in a condo if you don't have fines in your declaration. It's a good question. Now, there are also judicial enforcement methods. So if somebody violates a restrictive covenant, they haven't responded to your letters, the fines don't seem to be working, you can file a lawsuit to get an injunction from a court that orders them to discontinue their violation or affirmatively fix something that is broken. If you end up successful, they'll pay your attorney's fees. You can end up with an injunction, and then if they violate the injunction, they can be held in contempt of court, meaning they can pay fines and even go to jail. It doesn't usually result in somebody going to jail, but I have seen it happen when people are obstinate enough to refuse to do something even after a judge has ordered them to do so. Now, self-help remedies are the authority granted to an HOA to unilaterally correct a condition of a violation. It's got to be authorized in the documents. Even in a condo association, if you want to use self-help remedies, it better be in your declaration. Now, typically, the association has to provide the homeowner advance notice, and even if your declaration doesn't require that, you ought to be giving people advance notice that you're going to go on their property and take some action unilaterally. It would be a real bad idea to do that without telling them first.
Like a force mow?
A force mow. Sure, a force mow, or you have the right to correct other things as well. But if you're going in someone's backyard to mow the yard, or you're going onto their property to mend the fence or tow off a vehicle, you ought to tell them why you're there and what you're doing. It's certainly not going to hurt to give them advance notice. Now, of course, if what you're doing is going to put out a fire because it's an emergency, maybe advance notice is not required, but it's going to be pretty rare that you have an emergency that's equivalent to a fire to use your self-help remedy.
And in a condo leak or some issue that you need to gain entry into the unit and stop the issue because it's starting to affect other units.
Oh, if we're talking about a stacked condominium,
yeah.
It's 10 stories and unit 901 on the 9th floor is leaking and it's dripping down the whole condominium, and we know the leak's in there. You knock on the door, and if they don't answer, I would suggest you kick the door down and go turn off the leak. You can always fix the lock. You can always apologize and pay for damages that you caused. But if you've got a serious leak in a condominium, you've got to get that thing fixed, and you're always going to have the right to do That's just the nature of living in a condominium community. The obligations to the collective outweigh the rights of the owner.
One that we get often is kind of dealing with backyards. Somebody just, house isn't, is vacant or grass is growing, out of control, rodents are starting to become a problem. Suggestions on actually forcing yourself into somebody's backyard.
Yeah, I mean, the letter that we usually send, because it's not really an emergency. I mean, the rats aren't going to infest the whole neighborhood in 3 days. I like to write them a letter that just says, listen, this is a problem and you need to fix it. And we're going to fine you if you don't. But here's the other thing, we can fix it for you. And typically it's going to cost about $150. If you want us to just do it, call me and tell me, and we'll just go mow your yard for you and then charge you, and that's fine. If you don't contact us though, in the next 5 days, we're coming to do it anyway. And you probably have the right to do that pursuant to the declaration, but I would give a little advance notice. And since you're going to pay for it and they're going to be on the hook anyway, there's no need to raise the level of animosity. It's, hey, here's an option. You pay us. It's going to cost more than if you did it yourself, but we'll do it for you. You're just going to be on the hook, and we're going to file a lien against your property. Now, typically, if you have the right to self-help, you also have the right to charge the owner for the work you've done. And unless it is a clear, unambiguous violation, this is kind of your last ditch effort. You really want to stay away from self-help and demolishing people's structures and modifying what they've got on their property, unless it's a very clear, very unambiguous violation. Now, the authority to fine a homeowner must be found in the HOA's governing documents or state law. So we talked about condo associations. You've always got the right to levy a fine. Subdivision associations do not have statutory authority to levy fines unless it's specifically authorized by your governing documents. The most common enforcement mechanism utilized to enforce restrictive covenants is judicial enforcement. As I mentioned, you can get injunctive relief. That's an order from the court making somebody do something with respect to their property. You can get civil penalties. So while you may not be allowed pursuant to your declaration to fine, if you file a lawsuit, Chapter 202.004C of the property code authorizes you to ask the court for up to $200 a day as a statutory fine. So this is another incentive for folks to fix these problems. And of course, under 5.006, the property code, you can get your attorney's fees for enforcing restrictive covenants. Failure to comply with an injunction, as I mentioned, can be enforced through jail time and fines. All right, so with respect to enforcement of restrictive covenants, as I mentioned, there's a 4-year statute of limitations. The clock runs from the date the violation was discovered or should have been discovered. Should have been discovered in the sense of HOAs is really, would it have been apparent to somebody doing a regular inspection of the property? If you can drive by and see it, you probably should have discovered it the day that it was constructed. If you can't see it by driving by because it's in the backyard or it's otherwise obscured or something like that, then the discovery rule will apply, and it's going to be when someone actually discovered it and reported it to the association. There are also the affirmative defenses of abandonment and waiver. Waiver is the voluntary and intentional relinquishment of a right to enforce an applicable restrictive covenant. A good rule of thumb is if you can drive around the neighborhood and 10% or more of the owners in the community have an apparent violation of a restrictive covenant, then you probably have waived the right to enforce it. But the legal principle is that the violations existing were so extensive and material as to lead an average person to reasonably conclude that the restrictive covenant had been abandoned. Among the factors to be considered by the average person are the number, nature, and severity of the then existing violations, any prior acts of enforcement of the restrictive covenant, and whether it is still possible, because of the passage of time, to still realize a substantial degree of the benefits intended through the restrictive covenant. And then the Supreme Court has kind of boiled that all down to, well, if it's more than 10%, you've probably waived it. Now, there are risks to not enforcing restrictive covenants. In general, if you don't enforce the restrictive covenants, you will get more violations. The non-uniform enforcement may also cause there to be claims of discrimination or being singled out by other homeowners. Non-enforcement over time can create potential for a restrictive covenant to have been deemed waived. And enforcement of restrictive covenants is subject to a 4-year statute of limitations, which just means you should act as quickly as possible if you ever want to enforce a restrictive covenant. Also, if somebody builds something and you're going to ask them to modify it or tear it down, the sooner the better. If you let it stay there for a year or two, you might be within the statute of limitations. But as time passes and you tell an owner that what they've built is in violation of restrictive covenants, I will just tell you that the level of animosity increases. So the sooner the better when you're enforcing restrictive covenants. So here are some best practices. Have uniform and consistent enforcement. That means treat everybody the same. If the board gets together and goes, well, that shed's really ugly, we need to send those people a letter. Well, you better drive around the neighborhood and make sure you're sending a letter to everybody in the association with a similar violation. You can't just single out one person. You might be liable for selective enforcement. Adopt an enforcement policy. Don't have as one of your agenda items each month talking about what are we going to do to each individual violation. Have an enforcement policy and then delegate that to your management company and enforce it equally. Photograph and date each separate occurrence of a violation. You will never have too much documentation of someone's violation. And if this ends up on my desk, the thing that I'm going to look for is what evidence do you have to support these violations. Photographs are pretty easy to take and they're the best evidence. Require homeowners complaining about their neighbors to do it in writing and sign an agreement to cooperate. A lot of times people think that they have this right to anonymously complain about their neighbors, and that's fine. If they're complaining about the trailer in the driveway and they supply a picture, you can act on that without them participating. But if what they're complaining about is the barking dog that keeps them up at night, or the guy that is on his back porch doing something that only they can see, then you're going to need their cooperation if we're going to go and file a lawsuit. And if they want to remain anonymous, that is their right, but we can't do anything without a witness. And so the Texas rules of evidence are going to come into play here. And I would encourage people to either provide photographic evidence or a complaint in writing where they agree to cooperate if we have to go to court.
And we get those requests as board members all the time of, people having parties, things that typically our compliance driver can't document. And at what point should a board get involved in those neighbor to neighbor type, issues where only one, neighbor is complaining about the issue?
If only one neighbor is complaining about an issue, then you need to kind of have your antenna up. Sometimes neighbors have disputes amongst themselves and the HOA really shouldn't be getting involved. If it's an issue that's affecting more than one person in the neighborhood, I'll put it this way, the more people that are affected by the bad behavior, the more likely it is to be reasonable for the HOA to take action. If it's just one neighbor and there's really no evidence being provided, it's tough to do anything about it. And that goes back to my advice earlier, which is this might not be the purview of the HOA. We're not saying there's not a violation. We're just saying we're probably not going to get involved because we don't see the benefit. Violation enforcement costs money. We don't see the benefits outweigh the costs. But look, it's up to you. Go hire your own lawyer, give them the evidence you've got, and you can proceed from there. Again, it's a balancing act. You're on the board of directors. You've got a fiduciary duty to manage the finances of the association appropriately, and enforcing the restrictive covenants is one of your jobs. At the same time, the violations need to be of a material nature such that when you enforce them, the benefit to enforcing it outweighs the cost. And so those are the kinds of considerations that you'll have to take up as a board.